Good morning, everybody. Thank you for coming. My name is Paul Hennessy. I am the head of the Governance Task Force. I'm also a board member. And the first order of business would be to thank all of the members of the Governance Task Force, most of whom are here. Beverly Fierro is on my right and Amanda Mole is on my left. I saw Glenn Thompson online. Andy Capelli is here. And not here are Kelly Satch and Chris Pickler, who has been with us. I also want to be sure to mention the contribution that staff is making. They're an integral part of this process. They do at least as much work as those of us on the task force do, and it would be a hopeless effort without their contribution. So the purpose of the meeting this morning is a part and an important part of the process that we have embarked upon to improve the governance framework for the association by submitting to our membership for amendments. You will know, if you have looked at our website, that we have a meaningful process that is underway. It provides you with a lot of plain language information. It provides you with documents. It provides you with an FAQ. Importantly, it provides you with a survey. And I'm pleased to say that we've already received a significant amount of survey feedback, not just of the digital kind, yes, maybe, or maybe no, narrative feedback. So if anyone here or anyone listening has not taken advantage of that survey, I hope you will, because we plan on going through the input very carefully and mining that information for suggestions, ideas, concerns, and hopefully incorporating those into the process. This is going to be a heavy lift. And there's two parts to it. The first part is crafting amendments to our association covenants that are unambiguously good for the members. That's key deliverable number one. Assuming that we get there, key part number two, which maybe is more difficult than part number one, is getting 60% of our members to express their view formally through a ballot. Now, we do have an opportunity, if we don't get to try a second time, and then the quorum requirement drops to 50%. But that's going to be hard. 2/3 to 3/4 of our membership is part-time on the island. So this is going to. So bottom line, there are two parts to this. One is reaching agreement among the members, and then formally with the board, that what we're proposing to do in these four amendments is unambiguously, overwhelmingly good for the community, and then the voting, the communication and voting process. Now, fortunately, staff does have experience doing this. We have an excellent communications team, so I think we can accomplish this. And of course, these two tasks are interrelated, right? To the extent that what we're doing is perceived broadly as being good for the association, that should draw votes. So they're linked, but they are two separate processes. I also want to emphasize that the feedback that we're getting, either anecdotal feedback, which we've gotten from some people, through the task force, which has provided a lot of helpful feedback, through the survey, through meetings like this process of getting feedback is continuous. I don't want to think of it as, okay, we're going to do these three things. I'd like to ensure that the community feels like they can provide us feedback either broadly or in detail, whichever they wish, or both, because we're going to do our best to pay attention to that and absorb that, up to including the board meeting that we expect to formally present this at on the 6th of May, which will include final amendment language. So all of you, all of the members of the association will have an opportunity to see the final draft documents. We'll provide you with red lines so you can see exactly what changes have taken place relative to the covenants themselves or relative to the enforcement amendment that was passed in 2018. So we're going to try to be as clear and unambiguous with you as possible. But the point I'd like to just leave you with is the more feedback we get from the community, the better the product is going to be. Okay, so the only other thing that I would like to say today is we would like your thoughts, suggestions, criticisms, suggestions on two things. One is the process that we're going through to ultimately get the membership to approve these important elements of our governance. And then secondly, on the 4 amendments that we have put on the website for your consideration. One has to do with the developer-appointed board seat. One has to do with creating the authority of the association to have an architectural review function. Thirdly is an update to an amendment that was passed by the members in 2018, properly recorded with the county. We want to regularize all that. And then thirdly, some administrative changes that we're incorporating through an amendment having to do with nomenclature, the town versus the county. These are non-substantive administrative items. So those are the 4 amendments. So I'm going to open the floor. Our job here is basically to listen. If you have questions, we'll do our best to be responsive to them. But we want to get your feedback. We want to understand what's on your mind. If something is troubling you, if you're uncomfortable with something, we'd like to know what that is. My only caveat is that this is not going to be a drafting session. If you have specific thoughts or concerns or suggestions relative to the amendment documentation or language, we would love to have that. But I don't know that it's going to be most productive for the task force to get into drafting suggestions. So the overall process, what we're trying to do, why we're trying to do it, and then feedback on any of the 4, really any of the 3 amendments, the floor is now open. And Ellen, if we have hands raised, don't leave me.
Paul, are you going to take them one by one?
Yes. And, you know, Judy, I kind of thought, well, maybe we'd take the process first and then but I don't want to put that constraint. So any comments, any suggestions? Yes.
This is just a clarification, and forgive me if I shall run this, but could you go through the timing one more time as to when the KICA board will
yes.
receive it and then when we have a vote?
Yes. So It's a good question. So if the question has to do with the timing, the calendar in the process. If we go backwards, what we want to be able to do is ensure that all of this is done before the annual meeting in next year, so 2025. Okay, in particular, because that's relevant to the First Amendment that has to do with the appointment rights of the developer to appoint a director. We don't want to create a gap on the board, and so we want to synchronize this effort so that we can have an election process in the normal course, but hopefully also filling that vacancy which we intend to occur on the last day of our governance year. We're planning to go to the board on the 6th of May, so 2 weeks from now. And and again, important to emphasize to everybody listening in or here, that will be a formal public discussion with the board so that everyone has another bite at the apple. Plus, we will have completed a legal review. So we have gone to our KICA counsel and to get advice to make sure that what we're saying is clear and understandable, is not contradictory to other documentation that is relevant to the association, make sure it's legal. So when we go to the board, we will have had community input from the online survey, have community input here. They'll have lots of input from the task force. So the board will meet, and the board will formally approve, or not, or modify what the task force is recommending in terms of going forward, and language. So the language will be quote unquote locked down at that point. Then, assuming the board approves this, then we go into the second part of the challenge that I described earlier, which is to say a broad-based communication to the membership, which hopefully will result in ballots, electronic ballots, or if necessary, paper ballots, but ballots going to the members this summer, so August. And so there's that preparation, then there's the time that you need to give the membership to vote. Meanwhile, we'll be meeting with members. I was discussing with Carol before the meeting started to try to get visibility with each of the regimes so that we can have conversations, so we get more granular in terms of input. So board meeting on the 6th of May, voting in August, plus or minus, hopefully approval, a formal filing with the approved amendments with Charleston County, and then the changes go live at the end of the year to the next annual meeting. So that's broadly the schedule. Now the one wrinkle is that if we go to the members and we don't get quorum, so the initial quorum is 60%. If we don't get quorum, we have another shot, as described in our existing documentation. The quorum on the second Friday drops to 50%. So we've allowed time in there so that if we have to go back a second time at a slightly lower quorum requirement, we have time to do that. So that's the timing, and if I didn't say it already, regardless of whether the quorum is met at 60% or the quorum is met at 50% of the voters participating, we need a 75% hurdle rate, approval rate. So, I mean, free money, you might not get 75% approval. So this is going to have to be very carefully done, and that's our job, and today is part of that. So it's a great question. I'm sorry for the long-winded nature of it, but there are some moving parts. Okay. Questions online, Alan? Okay. No. Other questions here, please. Suggestions, ideas, thoughts. Yes,
on the
Carol. Sorry?
My question is, you looked at all the covenants and those are the only 4 changes you want to do, or are these just the ones you want to do?
Okay, great question. Thanks, Carol. Our governance task force is 2.0. Governance task force 1.0 worked on critical changes to the bylaws. That took a very long period of time. What we're doing, I think I can fairly say, is harder, and we're going to do it hopefully in less time. But we are contemplating that there is going to be another phase. Both our predecessors on the initial governance task force had a whole laundry list of things that they want us to consider. The board gave us direction and focus on these 3 major covenants. And so that is our mandate, but by no means have we forgotten or abdicated or ignored the advice that we got from our predecessors of things to do, including things like in the covenants, there are lots of decision opportunities, but the quorum isn't always required. Well, okay, the members have to decide, but it's not specific as to quorum. That's maybe one example, but there are lots of those examples. So it's a good question. This is an important step, but we are committed to continuing to plug away at issues that we think need to be addressed to improve the governance of the association, and that our predecessors have left us a long legacy of things that they would recommend we tackle, and we're going to try to do that. Yes, in the middle, sorry, I don't know your name.
One of the things that was discussed in the covenant changes was the ARB, the transfer of the ARB. Is that going to be more specific in timeline? Like, are we looking at by, I know this is wishful thinking, the end of 2025 or 2026? Is there going to be a timeline listed there, or is it going to be very open-ended? Because I think that's an issue with the community. So are we going to get some specifics?
Right,
when
okay.
we do something on that?
So just for the people online, it's another excellent question. How specific is the timeline and the process around the ARB amendment? Our effort is to ensure that by vote of the members, KICA, the Homeowners Association, has the authority to have an architectural review function. We are being agnostic on the form that architectural review function could take. And to your specific question about timeline, there is a separate process that is going on. It is a constructive process in collaboration with members of the town and the developer to craft a transition for the ARB from the developer to KICA. Now, I cannot represent the timing or the outcome of that. What we're going to do, what we hope to do in the second of these amendments having to do with ARB is authorize clearly and unambiguously the right of KICA, the homeowners association, the community association, to have and operate an architectural review function in a manner which the association decides is appropriate. We're not going to try to architect that. We're not going to try to decide that. We're not going to decide how long or how quickly or who the members are, what their governance is. All of that work is going on in parallel on a task force that Kevin Donlin and his counterparts at the town are working on with the developer. The developer has made several proposals that relate to this transition. I'm not suggesting that we agree with them or that there is consensus, but our job is to create the capacity, the legal capacity, the covenant capacity for KICA to do this function. That is the guts, the heart and soul of the amendment that we're crafting. The details of that are going to be worked out, hopefully, consensually, by the task force that is in place and operating. They've gone through phase 1, they've gone through phase 2. Amanda and her colleagues have provided detailed operating framework, so a lot of work has been done, but a lot more has to be done. But our change in the amendment has to do with the constitutional foundation for KICA to provide this function. Yes.
Given the nature of this community in terms of so many part-time, kind of fractional owners, why is the threshold for quorum and approval so high?
Well, if I were a skeptical person, I could give you a skeptical answer, but I guess a more responsible answer would be, if you think of, and this is not a great analogy, but if you think of the Constitution and legislation, you know, one is easier to change than the other, and that's by design. I think when these documents were originally crafted, they were crafted intentionally to be very difficult to change. I think that was, and now everybody can have their own view of what the motivations were of doing that. But it's not unusual for HOAs for covenants to have a higher threshold. I believe ours is particularly high. And so it's a legacy burden that we have. We have not chosen to try to tackle that threshold, although we could, albeit with that approval level. And maybe someday that's something we will choose to tackle, but not, again, based on the guidance we've received from the board, that's not our mandate. But it's a bear. Yes, Karen.
Well, going back to the ARB issue, the task force, we talked about the partners offering a 5-year timeline, which I think the community thinks is too long. And so I think in your writing or wording of the covenant change, you'll have to be very clear on that, because I think that's the confusing issue. People are going, no, that's going to take too long, and you don't want them to vote no because of that.
So Carol, it's a good observation. And by the way, and I don't think I'm disclosing anything that I shouldn't. We met with the resort, we met with Roger to talk about this, and he had a similar concern, because of course the ARB is very relevant to him. Some of the feedback that we're getting, which certainly resonates with the task force, is that the community recognizes that the ARB has been a critical value creator for KICA. The tricky part of this transition is that we want to make sure that we can satisfy the community in terms of objectivity, consistency, no favoritism, all of those things, but without disturbing the professionalism and sophistication of an operation that has been in place successfully, I would say, for years and years. So again, it's going to be a very delicate process. I personally believe that it's more important to have the right governance over and above the ARB process than it is to try to mess with the electrical and plumbing systems, which seem to be working relatively well. But that's my opinion. But so I take your point, but we just want to make sure that KICA has the proper authority, the explicit authority to do this function. I think as a practical matter, there is going to have to be, and there should be, and there can be consensus on not only how to do it, but when to do it. If that does not happen, if I'm wrong, and we, try as we may, we can't come to a consensual agreement and a time frame that's acceptable, KICA does have leverage, does have some leverage in the authority that we're going to create. Now, the developer also has leverage because the developer covenants, which are a completely separate set of covenants, no surprise, are a very, very, very powerful document.
So just to play a little bit of devil's advocate, help me understand how KICA managing the ARB function will not run into the same issues that we currently have with the developers managing the ARB function. What will be substantively different?
Okay, so again, good question. So the question is, if we think there are challenges or concerns with a developer-run ARB, how is a KICA-run ARB, architectural function, going to be, how can we guarantee that it will not have the same flaws? Well, in the first instance, the motivations, the context will be different. In the existing situation, there is a development motivation, and in the second instance, where this is a KICA run, it's more of a homeowner orientation, which is not to say that there won't be continuing development, because there certainly will be, but there will be a governance. Today, the governance of the ARB is unambiguous. It's the partners at the end of the day, and I'm not impugning any individuals, and I'm not impugning the operation of the Architectural Review Board at all. I'm just saying today the ownership, it's not a bias, it's the developer, and the plan B is that the ownership and bias of the function will shift to KICA. With all the member-oriented input that implies. Now, again, I don't want to second guess, what that oversight of new ARB looks like, because it could have, non-KICA membership on the governance board, for example. It may not, I don't know. It might be good to have somebody from the town on it so that there's better coordination with the town. There's lots of different ways that could go. So to me, I think a KICA-focused, KICA center of gravity ARB versus a developer center of gravity ARB the bias will shift. Now, are there downsides associated with that? Sure, you approve, you did my neighbor, but you didn't do me, and then there's a big fight and so on and so forth. So this will never be easy, but I think just the fundamental binary change of developer-focused versus homeowner-focused is an inflection point. And there's a million details that have to be worked out, but we have smart people working on it, and again, so far, it's been consensual. It's not to say that there's agreement, but it's a consensual process, and that is the best way to go in my view, in my personal view, because I don't want to disrupt, much less disband an operationally competent function that exists today. Carol, you're bailing me out here,
Okay.
Carol.
Well, no, we'll switch subjects to
Come on up here.
the enforcement one.
Yeah.
The enforcement one, again, the thing with the traffic that people in the community didn't like, they're gonna give me tickets now. But can you explain the things since 2018 that you have not been able to enforce, which would be a benefit to our community?
So I think there are a couple of things. The most important thing that the enforcement amendment, the 2024 version enforcement amendment is going to do is eliminate uncertainty of that amendment. When we did it in 2018, after the amendment was approved, the South Carolina HOA law changed. What the association did was it registered, it put on file with the county the rules and regulations, but for some reason that is unclear, we didn't actually register the amendment that was approved by the members. So the biggest change that we're going to do is regularize from a legal and process point of view the amendment. We're not making fundamental changes to, if you look at a red line, and we are providing that between the 2018 version and the 2024 version, they are not radically different. The ability to fine, the ability to issue rules and regulations, the ability for the community association to take actions against bad actors in a short period of time, it's all there. So I don't think the principal thing that we're accomplishing is we're regularizing that 2000. There are changes, but I don't think they're material. I don't think they are a step function change.
So,
in terms of what KICA is able to promulgate in terms of rules and regulations, in terms of what it's able to enforce.
but I would think that I'm a rule follower, so I like if there's a rule, that there's a consequence if they don't follow. And you're saying that's not really gonna change?
It's not gonna change. We will have so give me a little room here. Takeaway service surfaces. You can lien your property. Now, the number of times we've actually done that, other than that, I think create consequences for people who don't comply.
Paul, I have comments about that enforcement. I mean, I don't know, now it was.
Fourth Amendment? Oh, enforcement, sorry. Go ahead.
The third comes.
Yeah, enforcement.
Enforcement.
Yeah.
Do you want me to make those comments now, or are we gonna get to them another time?
Ellen, is there a microphone on the podium?
No.
Oh, okay.
Rich, I'll speak loudly.
Okay.
I hear what you say, Paul, about the amendment not changing what had previously been approved. But I was opposed to those in the first instance in 2018.
You did or did not?
I opposed them.
Oh, okay.
Yeah. I want to say that the fact that passed 18 in this form in 2024, because there was much less community involvement and much less feedback from community members at that time. We've kind of moved ahead in a monumental way to have community involvement. I think this version is as flawed as the previous version was. And I would be opposed to seeing this version passed, just as I was opposed to having the version passed in 2018. I have lots of comments that I could make, but I want to try to be a little bit succinct.
Okay, well,
And then
good. Please share, whenever it's convenient, please share all of your comments.
Yeah.
Because I'm interested in getting it.
okay, I will make some comments
Okay,
here.
but please go ahead, but please go ahead.
Submit some,
Yeah.
and I want to offer my assistance in changing them if anybody wants my assistance.
Look forward to it.
First of all, the penalty does not fit the crime. The penalties, any violation, under the wording, any violation can result in any level of punishment. That means that a minor violation can result in excessive punishment. And the need for specificity as to what violation would result in which consequence is missing from this version. So that you could bar a member from using the pool for a minor violation. You could remove the right to vote temporarily for a minor violation. There's no impediment in the present statement that would require that the offense fit the violation. I think that means that I could be barred from the pool or from club or from Cinder Creek because I left my bike in front of my house or something like that. But that raises the question of who decides what the level of penalty would be. The new amendment doesn't specify who has the decision-making power to determine that a violation occurred, and that notice of violation is not only the violation, but also the proposed punishment. Who decides that?
Well,
It must be the staff, because the board is only mentioned as the people who would hear the violation hearing. The board is not mentioned except in that provision.
there are a number of people in the room who will correct me if what I'm wrong. But I believe that with some exceptions, violations can be appealed and appealed to the board. So I'm not suggesting, Judy, that you're wrong, and I value your input, but I believe that to be the case, number one. Number two, I believe that under the old amendments, the new amendment version, KICA has the ability to create a set of rules and publish an appendix with penalties. So
I don't doubt that.
So I
think
don't-
they have the power, but I think that they should be careful to adopt a rule that works effectively. I don't think this one, it's kind of like, this is the most boring amendment on the list, you know? And I don't think that people really plow through it and look at all the provisions as carefully perhaps as I might have done. Right now, the only provision that we have for enforcement is the association has the right to bring a suit, to go to court. And so it's necessary to have.
Judy, I don't think that's correct.
No, that is correct. Until these covenants were approved, they're not in effect right now, I don't think. Under the existing covenants, what it says is that the enforcement provision says that the association can take an offender to court. So this is an effort to give a range of opportunities to make an administrative process as opposed to a court process. I think I'm right about that, Paul.
Okay, this is it's a valuable point. I know that there is a debate about this, but if the way I read the KICA covenants, under the functions and power section of the covenants, the association has a right to conduct the business of the association, and to me that clearly relates to rules and regulations and fines associated with that. Now, but I accept your point, that if you feel that forget the old amendment, 2018, but just focusing on the new one, if you think that there is a disproportionate weighting of offenses and consequences, then we'll take a look at that, for sure. But I believe the process that we go through is that the staff does not make the rules. The staff recommends rules that are necessary for the appropriate conduct of behavior, etc., consistent with the strategic statement of the association, and has published, a set of fines. Now, if people don't pay the fines, or if they pay the fines as a price of doing business, there are escalation provisions that are on the surface not very pleasant, but they're needed because sometimes with an association of 9,000 people, we have bad actors and have to deal with that. But I'm not denying your or objecting to your observation. If you think there's disproportionate treatment here, we will look at that.
I guess I'm confused, Paul, because you're referring to other enforcement provisions that are currently enforced, and then, so I thought this was in order to fill a gap. I'm wondering why we're amending the covenants.
So my understanding, Judy, and this is not a legal interpretation, but my understanding is that while we registered our rules and regulations appropriately after the South Carolina HOA law changed, we didn't register the actual 2018 amendment that empowered us to enforce the rules that we published. So the rules themselves have been published, but the amendment didn't. We're going to correct that.
Right.
But the operational aspect of creating rules, publishing rules, registering rules, and publishing a schedule of fines, that process, we're not recommending to change.
Wait, so even though the original covenant from 2018 didn't get properly
They were,
submitted, we're still living under it?
that amendment was passed by the membership prior to the requirement in the state to file that change, okay?
Well, it had to be recorded.
It had to be recorded.
Right, and so what happened was in 2000, like, just to give you a time perspective that might help, and Shannon, jump in before I get this wrong. They voted in March of 2018 on this amendment, and it was passed by the membership. And I believe it takes 60 days for it to get into effect. At the same time, you have the 2018 South Carolina Homeowners Act that was passed by the South Carolina legislature, and that went into effect, I believe, June 1st of 2018. So we're working really close time-wise here, and what the 2018 Act said, all documents, even documents currently in existence, had to be recorded. All HOA documents had to be
Had to be
recorded.
recorded in order to
They
be
had-
effective?
Well, okay, so
See, that's the question I guess I'm-
Essentially.
it did say to be effective, it said they had to be recorded. Now, I've done a little research, I haven't seen where that's been challenged in the South Carolina courts yet, because, you know, there was a big rush, they had to be recorded by January 1st of 2019, so there was a big rush to the recorder's office of organizations recording documents. But
So we didn't make it, apparently.
I don't know, I wasn't here, wasn't involved, I'm just giving you just some context of what happened. I believe there's legal opinion, so whether or not these amendments, this amendment in particular is in effect, I mean, you could argue it in court.
Well,
So-
wouldn't it be correct that this gives us another bite at the apple? That we could change these if we wanted to make them more fair?
Yes, absolutely. I mean, this is going to be a new amendment.
Right.
Our judgment so far, our judgment is that the substance of the amendment that was passed by the members in 2018 was reasonable. Now, if we think actually they weren't reasonable and not enough people really paid attention, fine, we will take another look at it. Kevin, you wanted to make an observation.
Yeah, I think some of it we're getting caught up in the 2018 amendment. Forget that it never happened. We think, or we've been given advice by legal counsel that yes, KICA can create rules and KICA can fine people. The primary thing to me that this amendment does is it gives us, when people won't pay their fines, they just check out a KIWA, they let their house go bad, we can now lien the property to really put some teeth in those fines, and this also creates a clearer appeal process.
Okay, it does actually more than that, because the wording is not carefully crafted to limit it to that. I think if it said
Judy.
the failure to make an assessment would result in such and such, that it's any violation of any rule of regulation is how it's written. And so, also, it calls for a 30 days notice to the owner, and immediately upon that time, the penalties go into effect.
Okay, Judy, can I make a suggestion?
Right.
I'm very interested in getting the details of your concerns. I am. And so I suggest that we sit down and go through them in detail.
Okay?
And you have a chance to convince us, or vice versa, that we need to change this. I'm not pushing back on that.
Yeah.
I'm not pushing back on that. But I do think, and I think Carol mentioned it, it is incontrovertible that having an enforceable set of rules that are fair and with an appeal process, which is included, it is a necessary activity for any HOA, whether it's 15 members or 9,000.
Paul,
We have 9,000.
I don't disagree with you at all. It is the way this is worded and the way, in the details.
Okay,
Because it's more broadly written than I think people realize, and allows more drastic remedies for minor violations than people would realize.
okay, well, I look
So
forward
I'd be happy
to,
to sit down with you,
to,
yeah.
I look forward to it.
And I'll have greater comments and longer. This was my
Good.
short version.
Good. I love it, I love it.
Thanks.
Thank you.
Well, we have Jim Drossik online with a raised hand.
Hey, Jim.
Jimmy should be unmuted.
Hey, Jim.
Am I indeed unmuted? Hey, at first I want to thank the task force having sat in those chairs before. I know the complications of what you're going through. It's a lot of wrestling, but it's intellectually interesting. And so hopefully that's bringing some to the process. It's bringing some joy to the process, however you want to put it. Just you know, there's some internet issues that you guys are having, so we're losing, those of us online are not hearing some substantial portions of what's being discussed. And I assume this is being recorded, and I hope the recording will be clear.
It is being recorded, Jim.
Okay, because Paul, you know, especially in your interchange with Judy, there was a lot that was lost there, and I think that was an extremely interesting interchange of thoughts on the thing. I'm going to try to just stop me if you think I'm going into you know, talking about specific language, because I don't want to get into that. But since nobody's really, I want to start by talking about the process. Just a couple of things. It seems awfully rushed to me that the board might actually approve final language for this on May 6th, considering what we're hearing already. And I know I've had certain conversations with people about timing and, you know, why you want to do this so you can potentially have the election for a director. But either way, you're having a special election, as I pointed out. You're either having a special election for this amendment, or then if you had to wait to do the amendment until the regular election, do it as part of that, where you'd have probably a better chance of getting quorum, then you could hold a special election for the director seat for the replacing the development director after that, potentially. Setting aside the fact that whether it's actually necessary to amend the covenants in that regard, but that's another thing I'll allude to in a minute. You said in the Q&A that you're going to offer 3 options for voting, and I'm not sure that's consistent with the bylaws or South Carolina statutes. You said you're going to offer the option for yes, no, or abstain, and the statute pretty clearly states that the choices are for or against, that there's no abstain. And I just want to make sure that you consider that and make sure you have the proper legal opinions on that before you offer those as options.
Okay, I would just, thanks, Jim. For sure, we will get appropriate legal counsel review of the form and substance of the ballot and the balloting process.
Okay. I'm just going to roll on here and just stop me again. I assume people have already made some written comments, and I plan to submit some myself. When we did in GTF 1.0, we shared those comments with the community. Are you going to share comments that the community is making with the community?
We haven't decided exactly what form we're going to do that, but in substance, we are going to try to respond to every comment that we get from the community.
But are you going to share community member comments with the rest of the community?
Yes.
So we'll all be able to see everybody's comments, because I think that'll be helpful. You know, I'm hearing some very, very interesting feedback from the community, Carol,
Okay.
for everybody to have the benefit of that.
So Jim, we're getting, so if you're referring to the survey that we've done and or comments that we're receiving here, we plan to be responsive broadly within the community to all of the meaningful comments that we get. Now, we're gonna get hopefully hundreds of comments. Some are gonna be repetitive, et cetera. So obviously, we're gonna do some editing, but our intention is to be transparent and share feedback that we get from individuals broadly with the community.
So you're not going to share the direct comments that people unedited with the community?
You know, Jim, we haven't really decided how to do that. I don't want to commit until we look at the totality of what we get and what is practical.
Okay, I've drilled that subject into the ground enough. But yeah, I think you know where I'm going with that, and hopefully you will consider that. And I think again, in the spirit of full transparency, that would be the right thing to do. Let's talk about if what people haven't talked about yet, and that's the so-called substitution, removal, whatever you want to say, of the developer director. Why it was interesting to me that you chose to, rather than remove the company as a Type E member, that you just remove the rights of the Type E member to appoint a director. What was the subtlety of that? What was the reason behind that?
So we discussed this, Jim. It was a point of deliberation, and the determination that we came but first of all, your observation is correct. We are taking away the right of the developer to appoint a board member. We're not eliminating the Type E membership class per se. The rationale for doing that is that, you know, there are decades worth of documents that refer to the Type E member, and we don't know exactly where all of those references are, and if we abolish the Type E membership, there could be unintended consequences. But in the meantime, we think the benefit to the community is served by eliminating the right to appoint, because as near as we can tell, there are no other powers or entitlements associated with the Type E membership that aren't already shared by or exist with the developer or the company.
Yeah, my concern is your qualifying language there, as far as we can tell. And I wasn't suggesting eliminating the category of a Type E member, although other comparable associations have actually done that if you go through the covenants of other associations. I was suggesting removing the company as the Type E member as opposed to just removing their ability to appoint. And I'm really curious to know if there are indeed, if it's been gone through with a fine-tooth comb, because as you know, we have a very confusing and ambiguous set of governing documents, to make sure that that there are no residual rights that the company would retain, aside from the appointment of a director, if indeed they remain as a Type E member. And if they don't have any residual rights, why do they need to remain as a Type E member?
Okay, well, I hear you, and I think we've been relatively thorough. If you have reason to think that we haven't been, please let us know. But we don't think there are other entitlements associated with the Type E membership that don't otherwise benefit the company / the developer. We don't think that's the case.
Then I would suggest you consider then removing the company as the Type E member. I think it would be safer because it eliminates the possibility that there are any residual rights.
Jim, what we discussed was to move that larger question to the later list. And for this round, only focus on the appointment.
Okay. Just sort of following up on that, I hope that maybe legal counsel, you'll include that in their review and opinion as to making sure that they should opine that there are no residual rights other than this.
Okay?
And just on, it's just sort of skipping back to process, are you going to share that legal review with the community?
I don't know.
We don't typically.
Well, no,
It's
Kevin, in the case of litigation, you don't, but there's no proposed litigation here. So
I-
quite often the community association has shared legal opinions with the community.
Okay, we'll,
Hey,
Jim,
Jim,
we'll
if you have an
consider
example,
it.
shoot it to me.
We'll consider it.
Yeah, but ultimately it'll be a board decision, not a task force decision.
Yeah, that's a pretty, my understanding is in the past, that's been a very rare, if ever, occasion. If you've got examples, I'd love to see them.
How about the board appointment? The appointment, the expansion appointment opinion from Ally Jett.
Yeah, Shannon's sitting behind me. I think they did do that because it was such a big deal. You know, there was some time and expense involved in that. I will say that when I was in for part of the discussion on this issue, keep in mind that while there's a lot of legally focused people involved in this discussion, trying to get to 60% of the members to vote on this and not throw their hands in the air and walk away, I think the committee was also trying to keep it as simple and straightforward as possible. Because if you get into too much detail and people walk away, you don't hit your 50 or 60% threshold. So I think that entered into some of the keep it simple in this round strategy as well.
Well, not to mischaracterize what you're saying, Kevin, and you don't take this the wrong way, but that's sort of saying, well, if we don't inform them enough, then they won't think too much. I think that's
Well,
Yeah, I don't think that's how it's implied.
but Jim, I want to emphasize that we've focused on this a lot. I will ensure that we get appropriate legal review of this point, but we don't believe there are any entitlements that are unique to the Type E membership that don't otherwise exist. That's all I can say. Now, again, for people who are listening or here, and this is very important, the developer, the company will continue to be a member of the association and will continue to have votes. But what they will not have, subject to this amendment passing, is the right to appoint a member to the board. Yes, ma'am.
I'm confused. When you talk about the reference to, in the documents, all the references to the Type E member and that causing a problem in eliminating that now, don't those references talk about phasing out the Type E member years ago?
That's just for the board appointment, to be a board member. That's what it refers to.
Right. Remember that over time, the board representation of the developer has scaled down to now where they have based on the continuous ownership level of the developer, they are now reduced to this one appointment right. I don't know, did we answer your question or not?
I'm still confused.
Well, say it again then.
So I thought that was the elimination of the Type E member on board.
What the amendment that we are proposing to the membership is that we take away from under the KICA covenants, this is an entitlement, this is a board election entitlement that exists under the KICA covenants today. Our proposal is to amend the KICA covenants so that the developer no longer has the right to appoint a dedicated board member. That right will, if this amendment passes, that right will go away, as a result of which all of the members of the board will be elected by property owners. The homeowners, lot owners, and other commercial owners like the resort and the developer but the right to appoint will be extinguished. And that seat will be replaced by the membership based on the voting privileges associated with your property ownership stake.
So that is inconsistent then with what was in the documents before.
So we're talking about maybe different documents. What the documents that Amanda brought up, there's just a myriad of legal documents that over time refer to a type E member. Just, they say, like, even in this document, I think there's something that says the type E member has the right, or their employees can come onto the island. So we're not taking away that right. We're just referring to their ability to appoint a member to the board.
That is a singular privilege that they have to appoint a board member and not use their authority as a property owner to elect, to be part of the election process. That appointment right is going to be going, again, if the amendment passes. Jim's point, which is a good one, is that we want to make sure that not only did the e-membership status convey this unique board appointment right, but maybe there's some other rights that we should make sure go away too. And we're relatively comfortable that we know the answer to that, but Jim's point is, well, make sure that that's not the case.
And am I still there? Can you still hear me?
Yes.
Yeah, just sort of not to, without belaboring the point, which I'm about to do, of course. It just seems that if you eliminate the company as the type E member, it takes care of that without having to do anything else. And I keep hearing sort of conflicting, distinctions or arguments as to why that you decided not to do it. I don't have a clear understanding of why you're only eliminating their right to appoint and not removing them as a type E director. Did you discuss that? Did you actually specifically make that decision not to do that?
Jim, honestly, I can't recall whether we discussed it in that specific context, but we get your point.
Okay, yeah.
Thank
Okay.
you.
Yeah,
What else?
and just going on, it just stopped me if I'm going too far, because I'm going to get into some other issues here. If you go into, and I don't want this to be drafting, but it was interesting, if you go into section 4 of Article 3, you made some changes to the beginning of that, but you left in all the language about the 80% and all that, which has been very confusing to members for many years. And I'm not sure, I know you're trying to limit the administrative changes, but this one in particular, and where it discusses the type E member again, having certain rights. Let's say, for example, let's say the resort decides to sell all of its development properties to the develop back over to Kiowa Partners. Would that again potentially drop the threshold below 80% and bring these amendments back into play? I don't know how many units the resort could develop. I forget, but I just don't see, again, I'm concerned when I see them not being removed and I see type E director with certain rights, even though they may have expired, being part of, residual language in the document.
Send me a note.
I'm sorry?
Send me a note.
Okay. The other thing, the final thing I want to say in this is, well, two things. One is the ARDA, without confusing people too much or getting into it. As you know, KICA, there's a legitimate argument that KICA has a contractual commitment from the developer to remove the director without this change in the document. And I just wanted to make sure that if you're asking council to review the ARDA in the context of this amendment and making sure KICA is retaining all of its rights thereunder.
Sorry, your point is you want to make sure that by removing the right to appoint a board member, we're not jeopardizing other derivative rights that KICA has under the ARDA?
Yes,
Okay.
that would be the essence of it.
Okay.
And the final thing, I mean, Amanda is there. Is there a potential that the developer is going to contest this amendment?
I have no idea.
Well, Amanda's there.
Yeah, I mean, she can answer if she wants, of course, but I don't really think that's the purpose of this meeting.
Well, I think for the membership to have an understanding that I think if there's a risk that there's, I mean, the membership has been very concerned and the board about litigation.
Paul and I are meeting with Jordan when?
May
Week
2nd?
from Friday.
Right, we're going to have a conversation, Jim, about the situation. I think it's premature to answer your question.
Okay, thank you.
Sure.
Thank you.
All right, moving on to, I'm sure gratefully, moving on to the next topic.
Yeah, go ahead.
I'm working, let me just scroll down here. You'll take a look at that residual language. You'll take a look at that residual. I'll send you a note on that. Okay. Can you, I'm gonna skip my comments on the architectural thing. Can you provide the membership with a red line between the 2018 amendment and the amendment that you want to put in here? You didn't put this in a form, this language in here where I could do a red line my own, as I would have done. But I certainly share Judy's concerns. And what I'd like the task force and the board to consider, I think to properly put these in context, there should be a revision of the rules and regulations, which are currently a disaster, so that the membership knows exactly, if it grants KICA these powers, exactly what rules and regulations will be in place in association with that. Because the board has the right to change those from time to time. I think the membership needs to know what it's getting itself into as part of it. And I think that should be part and parcel of asking the membership to approve this particular change to the document.
Okay, the answer to the first part of your question is yes. We will provide a red line between the amendment that was passed by the members in 2018 and the similar, substantially similar amendment that we're proposing be approved now.
Paul, it's up on the website.
Shannon says that she beat us to it. It's on the website.
Great, thank you. I do have to go back to architectural control for 1 second. The language is interesting, and I don't want to get into changing it or suggesting specific language, but it says it talks about subject to any restrictions or limitations imposed by the association. Does that mean the board or the members? I'm talking about the end of section 1. When you say the association, does that mean you're going to come back to the membership, as you're saying, for a subsequent amendment, or does that mean the board, are we granting the board the authority? I think there's an ambiguity there. You don't need to necessarily answer that, but I think by that phrasing creates an ambiguity as to who exactly has the authority to approve the authority.
Well, I'm not, again, I don't have the document in front of me, but I think the answer to your question is the board.
Yeah, I think so too.
Yeah, are you talking about section 1?
Yes, section 1 of architectural control, the new section 1.
And where's
You're effectively asking the members to grant the board the sole authority to make those decisions.
To make what decisions?
What the scope of the authority of the new ARB will be.
Yes, the board.
Okay, if that's the case, I think you should be specific about that because I think it's ambiguous.
Okay.
Point taken.
Just a couple of minor points again, this is crossing into drafting a bit. When you get down to the language in this redone 2018 amendment section, there are a couple places where you refer to covenants or consolidated covenants. There's no definition. I think you should refer to the KICA covenants, which is what they're defined as. And I'll point that out in a specific comment. But there are a couple of things like that. You must have gotten this language from somewhere else because there are a couple defined terms in there that are not defined.
So
a
Jim,
definition of consolidated covenants.
Jim, any detail that you can send us on any of your points would be very helpful.
Right, and, yeah,
Glenn,
definitely.
Yeah, Glenn says.
Sorry, Glenn, did you have something you wanted to add?
I just wanted to point out that there is a definition of consolidated covenants. And just to mention to Jim's earlier point regarding the type E member, the only other references to type E member in the covenants related to the ability of the type E member to basically enjoy the right of easement on the common properties and the right to use those common properties, as well as the right of the employees of the member to access and enjoy the common properties on the island, subject to the rules and regulations of the board of directors. So there's references, those, if you want to look at them, they're in Article 4, Section 1, the first two paragraphs. Other than that, everywhere where a right of the a company appears, the term company is used as opposed to type E member. So you can look at that section and decide if you think that those rights ought to be eliminated. I think we thought that those rights of the company or the type E member should not be eliminated, just voting rights. And of course, the fear was that there might be references in other documents other than the covenants to a type E member that might be lost if we totally eliminated the reference to the type E member.
Right, no, thanks, Glenn, that's terrific, I really appreciate that feedback. Yeah, I think, the company still has rights by virtue of being they may be an A, B, and C, D, A, B, C, and D member. So they still have the rights. I think at the end of the day, my view is that they should have no more or less rights than any of us have as homeowners. And I think that should be the goal at the end of the day. So it's an interesting question. And as Beverly said before, the question is, should that be addressed now or later? I just want to make sure that there are no other things, because it does, in addition to that, it does refer to this 80% test, the type E member having the right to appoint more than, some of that language is a little bit ambiguous. I'm concerned about it, and I wish you'd consider taking that out. But thanks for pointing out section 4, and I think that's something to consider. Again, whether that's it's less important than everything else we're talking about, but I do appreciate that reference.
And Jim, just to clarify, you said that the company would have the same rights as any other homeowner. It's any other property owner.
Property owner, yes. Well, yes, I guess you'd include the resort in there, but it should have the same rights as us. I said us homeowners to be specific, so. But yes, for somebody who owns a lot, yes, it should be the same thing. Other than their voting structure is different because they have B, C, and D properties, which are their assessments are calculated differently. On the 2018 to sort of split the difference, the association on the 2018 amendment, the association right now does have the right to lien properties for the failure to pay dues. So, but it's limited to that, because it was sort of in between what you guys were saying. It doesn't have the right to lien properties for fines under the current.
Okay. Okay, yes, ma'am.
I have a question based on something Jim said. In this election of this type E member, is the election now going to run the same amount of time as any other board member, like a 3-year or a 2-year period, or is it the election
Well, it would be the same term.
same terms of 3?
I think.
Well, you have to do the math, like, because we have, it's supposed to be, we have 3 3s, no, we have 2 2 3 now, 2 2 3. So we have 7, so we just did a 3. So I think the next one would be a 2, and if we filled Amanda's seat, that would also be, I think, a 1, or that'd be a 2 as well to keep her on track, right? If you did another, we have to do
I
another.
know, but I'm just saying it would be either a 2 or a 3.
Yes.
Yes.
That's all I'm asking, is it a period of time?
Yes.
Okay, so it's not a long-term, thing.
No,
Okay.
it's a
No, it
regular
would-
board member.
No, it would fall.
Regular board member.
Okay, that's all I'm asking.
So I'm trying to wrap my mind around the voting rights and the time A, B, C, D, E. Is there a way for a citizen to know how many members are under each type?
How many members?
You want to know how many A members, B members, C
You want
members? and D?
members or you want votes?
Votes.
Yeah.
Do we publish that?
We don't generally, but we can ask the board, they'll publish.
Where I'm going with this is, I mean, that 75% of 60 or 50 is such a high threshold, I'm just trying to understand.
It's the same as the election, right? You
Right,
just
so
did
it's
two
the
elections.
same as the direct election. I don't know by category, B,
Okay.
A, B, C, D. I can tell you that the resort holds approximately, give or take, 10% of the vote.
Okay,
The master developer holds just under 2% of the vote.
okay, that's helpful.
Now, they have mixed properties. The master developer has mixed properties, A, B, C, D. So does the resort.
And so you would have a vote per each of your type of properties? So
Yes.
the resort could have a B, C, and D?
Yes, and the vote calculations are in the covenants.
They are, okay.
Yes, the
Thank you.
vote calculations are in the covenants.
Okay,
So obviously, if it's just acreage,
yeah,
it's a lot less vote
okay,
than developed homeowner.
thank you.
Yes, ma'am.
Yeah,
Did that
so,
answer your question?
Exactly, okay, it tells me where I need to understand.
so Shannon, it's not just acreage, right?
I was using an example.
As an example.
Oh, as an example, yes.
Commercial, like the sanctuary hotel,
There's,
is
Under roof.
assessed and holds votes based on the fact that it's commercial square footage.
yeah.
So it's the entire square footage of the hotel by the formula that's listed in the covenants, determines both their assessment and their vote.
Thank you.
Yes. Did that help?
Anything else? Okay, so, Judy, Jim, others, we want to understand completely your issues and concerns, and we'll pay attention to them, and we'll think about them, and we'll discuss them. Okay, any other final thoughts, questions? In that case, I move for adjournment. Thank you very much for attending.